Call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Jonna Creed versus David Perry, case number 24 AP 160. Representing the appellant, Jonna Creed, is John Welch Jr., and representing the appellee, David Perry, is Eugene Rakow.
Good morning, counsel. We'll hear from counsel for the appellant first, of course. Please, for the record, introduce yourself, identify your client, and then proceed.
Yes, Your Honor. This is Attorney John J. Welch, Jr., and I am representing the appellant, Jonna Creed, in this matter.
Thank you.
And by the way, yes, sir. I'm sorry, Your Honor.
That's all right. Please go ahead.
Okay.
Thank you.
Thank you, Your Honor. I'd like to reserve 1 minute for rebuttal. Briefly stated, Your Honor, we're here because Ms. Creed feels that she did not receive a suitable property settlement, nor did she obtain any spousal maintenance that she really needs. The property settlement, according to the court at page 8 of the order, stated that that property settlement was meant to be a substitute for spousal maintenance, and that therefore we would not need any spousal maintenance. The problem with the property settlement is that because of Ms. Creed's economically disadvantaged status, her chances of ever getting a mortgage are next to nil, and she'll never be eligible to get a mortgage loan to maybe ever refinance that house. And consequently, she's going to wind up having to sell the house if she can, or face foreclosure. And the difficulty that she's going to have is that she'll wind up, if she gets anything, having to rent and spend down the proceeds from that. The settlement awarded her by the court was much less than what the defendant even felt she deserved, which was payments for 10 years and not just 1 year. And likewise, he agreed she should have $800 a month for life beginning in 7 years since they were together when the pension was earned. And respectfully submitted, Your Honor, just the way and by way of closing up here at this point, I would just indicate that, with reference to my brief and my reply brief, she's been economically disadvantaged. She's on food stamps, and just one final remark is that when she left work in February of 23, she didn't leave a high-paying human resources job. She left essentially a minimum wage job because of the fact that one of her coworkers had lost his life, took his life rather. That's all I have, I think, Your Honor, at this point in time, and I'll wait for a moment to rebut.
Okay. Thank you very much. We'll hear then from counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. Eugene Rakow, representing David Perry, the appellee.
Thank you.
A couple of points that I'd like to make right away is my client has a high school education. Ms. Creed has a master's degree in human services. My client's employment, which is a critical part of the court's decision, is unique. And I often say these cases are unique, but this is. The parties separated in 2011. They were married in 1995, separated in 2011. My client lived in Boston, and during the entire time he was there, he worked 2 full-time jobs. It's almost heroic that he could do that. He's now 58 years old. He worked for a hospital. He worked for a community program at various times. He is currently employed, finally, with 1 job at a hospital in Boston. During that time, he took a job with Boston College, specifically so his daughters could get tuition assistance. 75% of their tuition would be paid if he were a full-time employee. He described how he would go to one job at midnight. He relieved of that job at 8 in the morning, or sorry, 7 in the morning, and then go to his second job at 8 in the morning and work till 4 in the afternoon. Essentially, this man had no life. He worked to take care of his children and to take care of the house in Vermont. He paid for the children's private education at Christ the King School. He recently bought a car for Ms. Creed because the car she was driving was not, in his opinion, safe. He paid the mortgage, taxes, and insurance on the home from the day it was bought until today. He's still doing that, which is roughly $1,000 a month. He put money into
Mr. Ranko, I don't mean to interrupt you, but this was a long-term marriage, a 28-year marriage, even though there was a long period of separation from before the divorce occurred. But shouldn't that be factored into some way of the distribution in a way that's that allows for his earning status and her lack of earning status?
Well, her lack of earning status is because she isn't working. She was working before, and she certainly has the ability to work. My client shouldn't be forced to work 2 jobs to make ends meet, and to pay what he was paying for the support of his children and Ms. Creed. As the court knows, the cost of living in Boston is almost as bad as it is in Burlington, Vermont. And so anyway, I think the court needs to look at this. He essentially was paying spousal maintenance for 13 years. And it was a 23-year marriage until separation. It's a 25-year marriage as of this time. So I think what the court did is it exercised its discretion in giving Ms. Creed what she wanted, which was the house. My client basically got nothing other than his pension. There were 2 pensions worth roughly collectively $22,000. Against that, he has a $15,000 debt to the IRS because he worked 2 jobs. They did not withhold enough. And then he has another pension that begins at age 64 that pays him $1,600 a month.
And that's a defined
Other than that,
benefit.
his car, that's what he's got.
The UPS pension is a defined benefit. It's not like an IRA, or it's not a 401k. He gets that $1,600 a month.
Correct.
Once he hits 64.
Correct. That is correct. So I go back to where I was beginning, which is I believe the court exercised its discretion. Neither party got what they wanted, by the way, which they proposed to the court. So in that discretion, the court gave Ms. Reed the house, gave her an opportunity to refinance the house. There's roughly $110,000, $111,000 of equity at the time of the decision. It's probably up by another $2,000 or $3,000. Again, my client's been paying for it. So she has the house. He has no property whatsoever other than his vehicle and the pensions, which we just described.
Okay. All right. Thank you very much. Does the appellant have any time?
The appellant
I
has
have 1
2
minute.
minutes. The appellant has 2 minutes and 6 seconds remaining.
All right, counsel.
Respectfully submitted, Your Honor. I would just make a few points here. Ms. Creed has been essentially out of the human services business since the year 2001. She's been working a full-time job as a primary homemaker for her children while they were growing up, and now they are grown up. She still has two daughters home going to college. The defendant, the appellee, now has only 1 job. He's only had 1 job for quite a while. He makes over $100,000 a year in that 1 job. He does very well for himself. And as Judge Cohen very aptly pointed out, this is a 28-year-old marriage. These folks were married for years. She's the actual effect of the situation is that she's going to wind up probably with around $90,000 worth of equity, as I argued in my brief. And by the time she's done, assuming she can sell the house for $200,000, and she'll have to rent that. If she doesn't sell it,
Appellant
if she
has 1
can't
minute
sell
remaining.
it, okay. If she can't sell it, she's going to wind up in foreclosure. She'll get nothing, and that's just not there's something wrong there somewhere. So I respectfully request that the court, in the exercise of equity, remand this matter to the trial court, to have the trial court take another look at this property settlement and this spousal maintenance matter. And thank you very much for your time, Your Honors.
Mr. Welch,
Okay.
I'm concluded.
Mr. Welch, one just quick question. I couldn't find anything in
Yes,
the record indicating that she had applied for a mortgage and had been denied.
That's correct, Your Honor. She has not applied for a mortgage, nor has she been denied. She did make the point at page 30 of her brief. Page 30 of the transcript, that I think that she wasn't unable to get a loan, I believe. I think, Your Honor. So she has not actually applied, Your Honor. This is true.
Okay, I think your time has expired.